specialise in computer implemented inventions and AI. Somewhat unusually for patent attorneys, I do have an educational background in computer science. All patent attorneys do have to have a science background, but a lot of patent attorneys who specialise in this area, they tend to have kind of physics degrees or electronics type degrees. I've got a PhD in automated reasoning, so I do have a highly relevant background. I lead our UK-wide software and electronics team as well. Before we start, a couple of quick housekeeping matters. If everybody could make sure that they're muted to help with the audio, and if I could ask that you keep the cameras off just while we're presenting, just to help with bandwidth requirements. Any questions, if you can just drop them into the question box, we'll pick these up at the end just to make sure that we can get through all the material in the hour. And then we'll have plenty of time for questions after, and if people can stay on, we're happy to stay on for a while. Okay, so what are we going to talk about today? So this is a quick outline of what we intend to cover. I'm going to talk about intellectual property rights in general. It's going to be very much a focus on patents and patents for AI. I'll give a very brief introduction to what patents are, and then talk a bit more in detail about computer programs and patentability in Europe. A few examples of AI, patentable AI inventions, very quickly talk about patents in the US, and then look at some Norwegian AI patent data from some research that we've recently conducted. I'll then give a quick introduction to copyright and a very, very brief introduction to designs and trademarks. Conscious a lot of this is brief, is quick. We're intending to cover quite a lot today, so it isn't going to be an in-depth, detailed discussion, but hopefully it will give you an introduction to all of these different areas. And then I'll hand over to Simon to talk through some legal issues. Okay, so intellectual property rights. As I say, I'm going to focus on patents. Very briefly, what is a patent? I suspect most of you already know this, but it's a monopoly right to prevent others from using the invention. By monopoly right, we mean it doesn't matter if somebody gets it from you. If they come up with it independently, you can still stop them doing it. It lasts for 20 years from the date that you file your application, and essentially there's a deal that you make with the public, with your nation effectively, and that's that you give up knowledge of your invention to the world. You agree to not keep it secret, and in exchange you get this monopoly right, this protection. There is a requirement that it has to be novel and inventive, so you only get this deal if the knowledge that you're giving up is valuable knowledge. What are patents used for? Again, things that I'm sure many of you will be familiar with. The traditional uses are kind of a defensive tool and an aggressive tool, I suppose. As a sword and shield, they're sometimes described. So the sword is protecting your product or your market, stopping others from entering into a market that you are in, and generating revenue. So, for example, through licensing. A shield, perhaps slightly less familiar as a use. That's making a deal. So if you want access to a competitor's patented technology, and if you have a patent for technology that they're interested in, then that can be a defensive tool. You can effectively get access to their technology by making a deal for cross-licensing. I think increasingly important, or perhaps not increasingly, but I think very important, is as an asset. This particularly for smaller businesses and startups. This is often part of a business plan for startups to provide something tangible, a patent that can be part of a sale. It's typically a really important question for investors, what IP is in place, and in my experience at least, investors are particularly interested in what patent protection is in place. So this can really help as an asset. And I think also as a marketing tool, as an indicator of innovation, I think this is something that Apple in particular have been very, very good at. They talk about their intellectual property and their patents in particular, and they market their innovation very well by way of their patent portfolio. As I said before, something has to be novel and inventive for it to be protected, and so it's an indicator that you have innovated. So what about software patentability in Europe? Well, there is lots of confusion in this area. I think I often hear that it isn't possible to protect software in Europe. And I think it's not particularly surprising that there's lots of confusion in this area, given what the law says. So this is the general position in Europe and the UK in particular. In fact, this is part of the European Patent Convention, so this applies across the whole of Europe. The law provides a list of things that are excluded from patent protection, and this includes computer programs as well as various other computer-related areas, business methods, mathematical methods, and the like. So it's not surprising that people think that you can't get a patent for a computer program, given that this is what the law says. But the law does also say that these things are only excluded insofar as something relates to one of them as such. So this leaves the question of what is a computer program as such, and more importantly, when is something not a computer program as such, and so that you can get patent protection for it. In Europe, the question is there a technical solution to a technical problem? If the answer is yes, then you can protect it by way of a patent. This shifts the question to when is something technical? Not necessarily a significant step forward to understanding what is patentable. Rather than we're asking, is it a computer program as such, we're asking, is it a technical thing? I'm not sure that's necessarily significantly clearer. But the case law does provide us with lots and lots of guidance on how to determine if something is technical. And actually the position in Europe is incredibly stable and very predictable based upon all of the case law that's been built up over the years. A good example from various ones of the case law, I think here is that a useful tool is to imagine an inventive process as a collaboration between an engineer and a business person. So what the engineer contributes, that's in the realms of technical and therefore patentable, but what a business person contributes, that's in the realms of non-technical and therefore not patentable. There are, as I say, lots of case law gives us lots of examples of things that really are very clearly patentable. And so if you are one of these things the case law tells you are okay, then you're technical, and the only question you have to answer is novelty and inventive step for it, as for any other kind of technology. So some examples of those, and this is really a non-exhaustive list, but just to give you an idea. If you have a computer program having a real world effect, for example, controlling a process, controlling sensors or taking input from sensors and manipulating that sensor data to provide some useful input, that is something that has a real world effect, and that is considered technical. Image processing, there's a long body of case law that says image processing is generally technical. So for example, if you're improving the quality of images, sharpening an image, or if you're extracting information from an image, so interpreting images, extracting features from it, that is technical. Data security, data compression, these are things that case law tells us is technical. And sometimes more challengingly, but nevertheless, there is case law that says this is okay. Improvements in computer performance, again, this is something that is technical. So if you've got an improved compiler, for example, or improved operating system features. Okay, so that's quick background on software, which I think you really do have to be able to talk about AI in particular, which I want to talk about in a little bit more detail. So is AI patentable? Just a quick note on AI. I'll use AI as a catch-all term for machine learning and related technologies. I'll try and use AI consistently, but that is what I mean by it. So is it patentable? Well, applicants are certainly filing applications for AI-related inventions. This is a trend at the European Patent Office. This is from the research that we've carried out internally. This is the number of publications in particular years, and you can see the trend is really quite sharp. The blue line is real data. The dotted line is a trend line, and you can see that there's significant growth since 2015. There's around a fourfold increase, I think, between 2012 and 2019. So are companies just wasting their money, or are they actually getting granted patents? Well, you'll be perhaps unsurprised to hear that they're not just throwing their money away and none of these are being granted. So here I've shown allowance rates for, so this is for applications filed since 2015. And it's pretty good, 63, 64%. That is the average across all of the applications in that time that have ultimately been granted or refused. And I put in there as a bit of shameless self-promotion, Marks and Clark's allowance rate, which is 75%. So even better if you're prosecuted by Marks and Clark for these kinds of applications. I should say this is AI related applications. Broadly parallel, 63%. That's roughly what you might expect for software in general. So how are people getting AI inventions granted before the EPO? The European Patent Office provides, I think, really good guidelines for applicants, for patent attorneys, in fact, to give them some guidance on what they might be able to protect. And in 2018, these guidelines were updated. The EPO is aware of this trend in increase in AI-related applications, and they've taken really positive steps to try and be, I was going to say ahead of the game, but given the trend starts in 2012, and maybe not quite ahead, but they are trying to keep up with this filing trend. So the guidelines give some guidance. They tell us that there are two safe harbors for AI-related inventions. Those are technical applications and technical implementations. I'll talk about what that means in practice, but if you can demonstrate you fall within one of these safe harbors, then you are technical and you pass the first hurdle, and all that you need to do then is be novel and inventive as for any other patent application. So what do these safe harbors really look like in practice? Technical applications is, I would say, the easier, the simpler, and actually the most widely relevant safe harbor to what most people are doing with AI. And what this requires is that claims are limited to a technical application. We've got that word technical again. And really that is the same use of the word technical as before for software in general. So if the EPO considered something to be technical as non-AI software, then it's also technical as AI. So things like image processing, again, speech processing, fault detection, where you're using sensor output data, medical image analysis, various other things. I've picked out some ones here that are particularly relevant to AI, areas where it is being widely applied, but this is, again, non-exhaustive. Again, control of a specific technical system or process. So if it's outside of the computer, controlling an X-ray apparatus, for example, that will be technical. Controlling a chemical process, that will be technical. And also, again, inside the computer, so resource allocation in distributed computing systems, another example of something that would be considered technical. More generally, if you apply AI to something that another industry would normally be able to protect, then you can also protect that for when you apply AI to it, when the invention lies in application of artificial intelligence. There are some important for AI problematic fields of technology. Some natural language processing can be challenging, and some recommendation systems can be challenging. Again, not an exhaustive list, but these are areas where we see AI being particularly applied. Now, I should say it is important to emphasize the some in this. We have obtained granted patents in both of these areas. It isn't a bright line. You can't get protection for natural language processing or recommendation systems. You can, but these are generally a little bit more challenging, and care needs to be taken if this is where your invention lies. So technical implementation, more difficult, as I said, but it does allow very broad protection for the AI itself if you can fall within this safe harbor. For a technical implementation, you don't require the limitation to a specific application field. And the case law, again, is a good guide. It tells us that to be a technical implementation, you have to be particularly adapted for the implementation, in that the design is motivated by technical considerations of the internal functioning of the computer. And that's a quote from one of the important cases in this area. By way of an example, an effect of an efficient hardware implementation of an algorithm. Now, I'll look at a couple of examples, an example of each of these, just to hopefully bring a bit more clarity to what this means in practice. As I said before, computer program as such is defined by the case law. What does as such mean? So I think examples are the easiest way to understand what it means. So looking first at an example of a technical application, a case related to determining irregular heart rates. If anybody's looked at patent applications before, they'll know that patent figures are always extremely helpful, and I'll talk through a couple of these. So in this figure, what we have is a person. The circle represents a heart rate sensor. The heart rate sensor detects output from the person. It detects the heart rate rhythms, and it transmits some data to a computer 600. And what the computer looks like doesn't really matter. What's important here is we have some sensor data. It's obtained from the real world, from a person, and then you do some processing on it. Processing isn't just do processing, it's a little bit more specific than that. And the processing here, again, very helpful pattern figure. What we do is effectively what's meant to be represented here is you do some clustering, and then when you get a new sample, a new heart rate set of sensor data, you apply your neural network to work out whether or not you fall within or outside of the normal range. Specifically, it used a Causation neural network, and I've put up one of the features of the claim here. You don't need to worry about the detail here, but what's really important in this claim in terms of this being a technical application is that the bit in bold, that this is a formed n-dimensional vector, and crucially that formed n-dimensional vector is formed from sensor data obtained from the heart rate monitor. So there was a technical effect. It reduces the number of false identifications of electrocardiograph signals, and this was considered patentable. It's perhaps worth saying here that how this becomes technical. So the Causation neural network in the abstract isn't technical, according to the EPO's approach. That is just maths, so far as the EPO is concerned, the European Patent Office. But it becomes technical by you applying it to this real world data, this sensor data. So the invention can still rely on the Causation, the use of a Causation neural network, but it wouldn't be inventive without actually applying it to this real world data. Perhaps more difficult, as I've said, technical implementation. I do have an example of a technical implementation, and this example relates to training a neural network. Again, I don't want you to worry too much about the figure that I've got here. The really important thing here is right at the very, very top. What we're doing here is using a CPU and a GPU, a standard processor and a graphics processor. And each of the boxes in this figure, they represent part of the process of training a neural network. And what the invention really relates to is dividing up that process for training a neural network into different parts and carrying out different parts on either the CPU or the GPU and passing parameters between. And what this gives you is a more efficient use of the underlying hardware to train a neural network. Again, I put up a claim. Again, I don't want you to worry too much about exactly what it says. Just a couple of important points to highlight. What this doesn't have in it is any specification of what is being trained, what the training data is, what we're training it to do. It is completely abstract. This is purely about the idea of doing training in a better way. And this could be applied to any types of data, including business data. And this was still found to be patentable. And the reason we don't need to have an application, a specific technical application in the claim, is because, as I say, this is a technical implementation. And what's important here in the claim is, again, the bits that I've highlighted in bold. We have actual parts of the hardware tied to the process that's claimed. So we do specify in the claim what is carried out where and on which bit of hardware. So this becomes technical by tying to the CPU and the GPU. Okay, so very quickly, the US position. The US is obviously a very important market. And I think the US, I think it's fair to say, has been a reason why software patents have been generally a little bit controversial in Europe. I think there were historically some very bad patents in the US, things that just weren't inventive, probably weren't new, for which patents were granted. The position was extremely lenient many years ago, and the position has changed quite dramatically over probably the last 10, 15 years. Originally, there was a case that said that anything under the sun that's made by man is patentable. And so this was interpreted as meaning that business methods are patentable because people come up with business methods, and so they must be something under the sun that's made by man. Recently, the case law has shifted quite a lot. There's been a few decisions of the Supreme Court, a couple of decisions, and they've changed the position in the US, at least in terms of how it's understood by applicants, attorneys, and the Patent Office. Now there is a prohibition on patents for inventions which are too abstract. A couple of important questions. Does it provide an improvement to computer-related technology? Is it capable of being performed without a computer? If it's capable of being performed without a computer, then you might struggle now in the US, whereas before it probably wouldn't have struggled at all. I suppose the key takeaway for here is the US position has become less lenient. It is closer to Europe, but there are still some differences. In Europe, whereas a link to a technical application is enough to make you within the realms of patentability. In the US, sometimes that cannot be enough. So a little bit surprising to most people is that in some instances, it can actually be easier to get some protection in Europe than in the US. That's not a general principle. I think the US is generally more likely to be more lenient than Europe, but it has come a lot closer together. I just wanted to talk through a little bit of European patent filing data. I thought it might be interesting to look at some comparative filing data, particularly for Norway. My team produced 2 reports on patents before the European Patent Office related to artificial intelligence. We published these at the beginning of the year. And I looked at the data we used for those reports and pulled out some new analysis for this talk, which I'll go through very briefly, but I thought would be just interesting to look at. So this is total filings in the last 20 years. And I guess of most interest to most people here is the number for Norway, but I've put in some other numbers as comparatives. This is straightforward total filings. So Norway, there have been 88 artificial intelligence related applications filed from Norwegian applicants, 13 filed in 2017 to 2019. Now that's not particularly useful, I guess, given the relative size of different countries. So I have population adjusted the filings. This is now looking specifically at 2017 to 2019. You might not be able to see exactly what the countries are there, but Norway is the red bar. This is adjusted per capita. And I've highlighted some other yellow bars that might be interesting. So in order there, Finland, Sweden, Germany, USA, and Denmark, France, and the UK. So you can see even population adjusted, Norway has relatively few filings compared to some other countries. Again, you might not be able to see the full detail of this, but I'll talk through the key points. What this shows is the number of applications, and this is again looking at the last 20 years, the number of applications that any given applicant has filed. So the blue bars in each of them are applicants that have filed 1 patent application in the last 20 years. And then the orange is 2, grey is 3, yellow 4, dark blue 5, and broken down by country. So what you can see is that Norwegian applicants, generally, if you file an AI related application, then you file either 1 or 2 applications in total. Only 1 applicant has filed more, with 1 with 3, 1 with 4, and 1 with 5. Looking at Denmark, Finland, and Sweden, there's quite a different picture. You do have relatively large filers then, not many of them, but you do have a number of relatively large filers. There are 2 unsurprising standout large filers, and those are Nokia and Ericsson, which you can see 289 and 325 that they've got applications that show up in our data, the next being 82. So that they do somewhat skew the data. So I thought I would look at what happens if you adjust for taking out Nokia and Ericsson. The blue line that you can see is Norway. It shows exactly the same data. I've just put it so you can pull out Norway a bit more easily. And the bars, so each of the data points is the number of applications filed in any given year. And what you can see is that even taking out Nokia and Ericsson, on straightforward filing count, Norway does do a little bit better, but still perhaps a little bit behind some of your neighbours. And again, I thought population adjusting, just to check, just a sanity check that it's not just an artifact of population, but you end up with a broadly similar picture. So I think, I guess the only real takeaway here is that Norway could file more applications, at least to draw level with some of their neighbouring countries. They are a little bit behind in terms of the number of cases that they file. I suppose one other thing that I didn't note, but in this one you can still see it. What is really surprising to me is that since 2015 there's a real drop-off in number of filings for Norwegian applicants, whereas the rest of the world has really taken off in terms of filings, and some of your neighbours have really taken off and increased. Norway has had a very surprising drop. I can't explain it, but I thought it was an interesting data point just to show. Okay, so I'm going to very, very quickly just compare and contrast some other intellectual property rights. Copyright is the main one I'm going to talk about, albeit still very brief. I do sometimes hear that patents aren't really necessary because you have copyright protection already in place. So I thought it was worth just looking at that point in particular. Copyright is a right to prevent copying. It arises automatically on creation of work if the work is sufficiently original. So it is true that you will almost always have copyright for your software because it automatically arises. But it's important to say it only prevents copying. It protects the expression, not the ideas. So it is really extremely limited in scope. The software code itself is protected, not what the code does. For artificial intelligence, for example, it protects against someone using your trained model, so they can't copy it and use it if you've got a patent that protects that model. But it doesn't protect against someone training their own model in exactly the same way and using their own model. It can't prevent them from doing that. You need to prove copying. It's usually sufficient to show that there was access and that there's sufficient similarity. So there is another barrier, but a relatively low one in terms of proving copying. So what are the pros and cons? I guess they're obvious, but there's no harm in highlighting them. Copyright, there are certainly some pros. It's free and it's automatic. Those are definitely advantages to copyright. In terms of cons, it's not a monopoly right. It only prevents copying. There is no protection for function behind programs, and that really is often where the value lies. Patent pros and cons, it's a monopoly right. It's almost the inverse you have here. It is a monopoly right. It gives you much stronger protection. It can protect ideas. It's not limited to the implementation. The cons are that you need to file an application, and that has two cons. One is that there is significant cost, and the other is that you need to disclose how the invention works. As part of that deal, you have to tell the world to be able to get that protection. It can be hard to prove infringement for some inventions. Patents are the only way to stop others from doing what you do, though. Even more briefly, trademarks and designs, just to give a full picture of all of the different rights. Designs, they protect the appearance of the whole or part of an article. So we've got some famous designs here, the Apple iPod. It isn't limited to physical things. It can also apply to icons and software. So this can be another layer of protection that you have for the software that you are generating. Trademarks, these indicate origin. They stop others taking advantage of your reputation built up in your brand. It can be extremely valuable. Here are some word mark examples. For example, DeepMind has built up a reputation as a leading AI innovator, and nobody else can call themselves a DeepMind product. That has a lot of value, that brand. It isn't limited to words. It does also extend to logos. Here are some very famous and extremely valuable brands. So Apple, Facebook, and Twitter. I'm sure these are very familiar to you. And very quick wrap up from me, just to cover off all of the different rights that I've talked about. So here's a quick summary. I think the key ones when you're talking about software really are patents and copyright. Patents protect how things work. Copyright protects the detail of expression. Also relevant and often having lots of value are designs and trademarks, as I say. So designs for your appearance of your product and trademarks for your brand. And that is all from me. So I'm going to hand over to Simon now.
Hello, yes, I'm Simon Portman. I'm a commercial lawyer on the legal side of the practice. So I advise on things like commercial contracts, securing funding and that sort of thing. I don't actually have a science degree. I worked in publishing and book selling and then converted to law and worked for a while in-house in the petrochemical industry before ending up in Cambridge in private practice. So my sort of route to this has been a bit more circumspect. Yeah, I think a good illustration of what the issue is that we now have AI. It's able to make decisions and process data at a much bigger volume than humans are capable of. And there is obviously massive commercial and technical potential in that, but at the same time, it's flawed in some ways, and we still have some way to go. I've got a couple of examples of this. One is an apocryphal example from history, and one is from my own personal experience. But the first one is that Robert McNamara, the Secretary of State under the Kennedy administration, who had started out as chairman at Ford Motors at a very young age. He was very into computer modeling and the use of data. And the story is that in 1967, he realized the Vietnam War wasn't going that well. So he fed into the Pentagon computer all the data on North Vietnam, all the data on America, everything regarding the military, the economy, the wealth, the society, all the resources. And he asked the computer, when are we going to win the Vietnam War? And they came back a couple of days later. I imagine there was a lot of whirring of spools of tape and flashing lights. And the computer replied, you won the war in 1965. Another example I've had from my own personal experience is, as you're probably aware, everyone at the moment in lockdown is doing a lot of online shopping, and the supermarkets have increasingly relied on algorithms so that if you order something and it's not available, they will come up with a suitable substitute. And one of the builders in my village, who was working while he couldn't do building, for Sainsbury's, said they used to collect stories of in the supermarkets about the most hilarious substitutes. And he'd heard one from a colleague in another supermarket who said that a woman had ordered a pregnancy testing kit and then substituted that with a packet of condoms. Now you can sort of see the logic there, but at the same time, we just know it's completely wrong. So, you know, that is the challenge here, is that we have to be able to regulate and control all these issues thrown up by something where there is a huge amount of potential, but at the same time, there is the issue that things could go wrong. And then how do you work out who was at fault and how do you regulate that? Next slide. So one of the issues is that it is the AI facility a product, a service, or something else? Now, in many countries, including the UK, the general rule is that software is generally viewed as a service. However, if it is combined with a product or it's supplied in physical media, then it's viewed as a product, and therefore product liability also kicks in. And there are two examples here where liability can be, you know, really important issue are firstly medical devices, where AI is being used for treatment or diagnosis. There is obviously the potential for it to do that much more accurately and much more quickly. But of course, if it goes wrong, then there might be an issue of how you identify that, and also you try to work out whether the fault is the manufacturer or the user or any third-party element. Also, you've got the issue that if you have AI that is being involved in treatment or diagnosis, it could actually be a medical device. If it's purely storing and providing knowledge, it need not be. But if it is actually involved in treatment, even if it's non-invasive, then it could at least be a Class 1 medical device. And therefore, you've got a whole load of regulatory hoops to get through to get authorization to put it on the market. Another area where liability obviously is significant is in the connected and autonomous vehicle field. As many of you are probably aware, the rollout of autonomous vehicles is not progressing as quickly as everyone thought it might, because people are beginning to realise that you've got the issue that, that the sensors and the hardware are still not as sophisticated as a human. They don't necessarily have the all-round awareness in the way that a human can see someone in a wing mirror or a rear mirror and interpret that as, probably producing an event that is going to have to be dealt with. Sensors can't necessarily do that. Also, sensors don't seem to have yet the long-range interpretation that humans do. So again, you can see that even if in many ways an autonomous vehicle might be safer, if things go wrong, it could be disastrous. So you've got to work out how to police the liability for that. Next slide. So part of the issue is that where you, the old forms of liability are that if someone does something that causes loss, or a company supplies something that is defective, then they are potentially liable for that if you can show a causal link between what they have done and the damage suffered. Now, obviously, it's very difficult where you've got machines making these decisions and often making them in an opaque way to actually come up with a way of linking the victim with the agent of the loss in the way that we used to be able to do so. And obviously that's causing real problems because it means that the old legal and contractual models aren't working as well as they used to. Next slide. So, there are various existing legal regimes that apply to this scenario, and they're going to probably have to be changed. One of those in England, and you get it in a lot of other jurisdictions elsewhere, is tort. This is the idea of civil liability. So if I have a duty of care to you and my negligence causes you loss, then you may have some redress against me. So in the same way, a manufacturer or supplier of a product or service, including an AI one, is going to be viewed as having a duty of care to the customer, even if they do not have a direct contractual relationship with them. So I might manufacture the product, resell it to a distributor, they sell it to the customer. If it goes wrong, the customer may still be able to come after me because of that duty of care. There is also the idea that you might be answerable to someone in contract. So if I sell you something and we have a direct contractual relationship, then I can be liable in the contract, depending on what liability I've taken on under it, if there is any defect and that causes you loss. And then finally, as I said earlier, if a product is, if software or the AI is going to be viewed as a product, in many legal jurisdictions, you also have the idea of product liability, which sits on top of the other two. Particularly, there is a big element of this in consumer protection, whereby consumers have rights which cannot be limited in a contract. So in all of these, though, you've got the basis that the person liable caused the loss, and you can see where the causal link is. And as I said earlier, that's quite difficult with AI. Next slide. So what can one do where this is the issue, where you may not, where you trace the problem back to defective programming or incorrect operation, but because of the lack of transparency and the complexity of the way AI operates, you may not actually be able to point to an individual or a company and say that they were negligent. One suggestion has been that you just impose an automatic levy on the suppliers of AI, so that there is some sort of automatic compensation regime, without you actually quantifying the loss. And companies could be insured for this. There's also the principle of subrogation, which means that if I'm insured for any loss, that then if I suffer that loss, my insurer can then go after the party responsible on my behalf. But again, they've still got to prove the causal link. Next slide. And there was a report a few years ago in the European Parliamentary Committee, which suggested that this issue might be solved if there was some sort of strict liability system backed by a licensing funded certification agency, so that there will be some sort of automatic compensation without you actually quantifying who was at fault and to what extent. And this report reported more broadly on the fact that there is going to be the need for as much transparency as possible in the application of AI, that a whole lot of regulatory frameworks are going to have to be overhauled, and that they're going to be heavily dependent also on hand-in-hand developments in other cutting-edge areas like 5G and Internet of Things, because in order for them to work, they're going to have to be networked. So, for instance, in the UK, the NHS is looking at how the current medical regulations can be overhauled to accommodate the challenges of AI, but it is a difficult challenge. Next slide. So I mentioned subrogation earlier, and one of the areas where it has been looked at is under the autonomous vehicle field, where insurers' ability to subrogate and bring claims against third parties, even if they weren't at fault, is being brought in. However, as I said earlier, it's still very difficult because it's often quite hard with AI to see what the link is. So it may well be that, in the future we come up with some sort of fixed compensation model. Next slide. Of course, another issue is that manufacturers and suppliers need to address these issues in their agreements to which they supply or license their technology, and make it, very clear where their liability ends, and cap it if at all possible. Now, in many countries, you can't exclude or limit liability for death or personal injury caused by negligence, so it's not really a get-out-of-jail-free card, as where AI is used in medical application. However, where, for instance, AI is used as a surgical assist or a tool in treatment and diagnosis, most suppliers are going to want to make it very clear that, it is a method to assist the healthcare practitioner only, and the final decision is always going to lie in the healthcare practitioner's hands. And to be honest, most doctors and consultants are going to want that anyway, because they want to be the ones making the final decision. So any company then is going to want to be quite careful about the warranties it gives about the efficacy of its product and any compensation it offers. But at the same time, you know, if it doesn't offer some sort of comfort, then the use of that product is not going to be particularly attractive to customers. Next slide. Another issue to bear in mind is that you know, AI is increasingly reliant on data, and it's going to be generating and processing it, and this is going to be used increasingly in smart devices, both handheld ones and larger ones, and the more data, particularly personal data, that is used and processed, the greater the challenge is to actually maintain people's privacy. And in the same way that a few years ago, the birth of the internet and of streaming and of downloads made the whole copyright regime very difficult to impose. In the same way, the exponential development of AI makes it very hard for meaningful privacy protection to be workable. Next slide. And the European Commission is aware of this, particularly where you're getting linked smart transport, where of necessity, personal data is going to be held and generated in terms of what people are doing, their performance, their location, because if you're in a vehicle moving around, that's going to be recorded. Patents are going to be derived from that. And of course, where you are and what you're doing can all be personal data. So it's very important that, you know, that data is out there and it's going to be all part of the network, but people are going to want to know that it's going to be protected. And that is another real challenge. Next slide. So one of the real challenges with the data in using it in the AI field is because there is so much data being generated and used, it's very hard to police who is the data processor, who is the controller. If there are potentially there are multiple parties doing it, multiple parties generating it, and then you've also got the issue of who owns that data. You know, if data is being generated in connection with you as a patient, you know, who is going to own that? Who has the right to use that? If data is aggregated, can you own those aggregated rights without requiring a license to the original background data? How realistic is the anonymization of data going to be? You know, how is consent going to be meaningfully given if there is a huge amount of very fast automatic decision making being taken? Next slide, please. So those are the real challenges there. One of the final points to bear in mind is that currently under the Data Protection Act and its equivalent GDPR laws in the European Union, someone has a right to have their data protected from automatic decision making. Now, of course, data protection in an AI sense is very difficult because AI, of course, of necessity involves automatic decision making. So it's going to be very difficult to see how we're going to be able to make those two join up together. So that's a real challenge moving forward. But I think we're going to see over the next few years an evolution in the regulations, in the compensation regime, and in how contracts are drafted, so that companies and the users of their products get the necessary protection. So thanks very much. I hope you found that useful. We've got some time now. If anyone has any questions, then please put them in the chat box and we can answer them. Failing that, send us an email after the event if you think of anything extra. There is a question up. Did you see that, David? It was about something you mentioned.
Yeah, sure. So the question is, recommendation systems, does it mean models that predict scenarios? The challenging area of recommendation systems are things like Netflix, which movies you might like, for example, or Amazon, you bought these things and so you might want to try and buy these other things. Those are the areas of recommendation systems that are problematic. The reason those are problematic is because it's about human intent, and human intent is something that the EPO doesn't really like. They consider it to be non-technical. I think I said recommendation systems aren't always excluded, and they aren't. So, for example, a medical diagnostic, as Simon touched on, something that you input various parameters of a patient into, for example, and it provides the doctor with a recommendation of what they should do. The input there would be technical input, it would be patient data, and that recommendation, I think, would generally be considered to be something technical. Similarly, if you're, for example, processing, recommending what part of a machine you should perhaps clean because it started to underperform. So again, you've got sensor data, you've got real life parameters being input into that recommendation system. That would be considered technical. So I'm always a little bit careful, or try to be a little bit careful when we talk about recommendation systems, because the ones that lots of people who are, lots of ways in which AI is being used, those kinds of recommendation systems can be very difficult. But it really is about, you might like this kind of thing because you're this type of person. That is problematic generally.
I think another thing to bear in mind is with any recommendation system, because you are, it's based on what you think people's choices have been in the past and what they might be interested in. If you are going to be using that to inform how your own future market research, or how you, in a commercial context, predict how you should target customers in the future, and in a, say, a healthcare context, any risk analysis of patients or patient groups. If you're going to be using the information in that way, you need to make it clear in your terms of use that you're going to be doing that, and any aggregation and analysis of that data should, certainly if you're operating in the UK and Europe, be in an anonymized fashion. I mean, the other thing there is that they're already finding that in using, say, predictive AI to analyze health risks for patients or patient groups, it's starting to generate analyses and predictions which are of themselves, very pertinent to individuals or patient groups, and unless you've got the right security measures in place, there is a danger of that information and those analyses being accessible to outside parties. So, the whole security and cybersecurity challenge is that much bigger with AI compared with what it was before. Yes, you may have a follow-up question.
I think if you want to just ask it. You're
Yeah,
welcome.
I think now we can start talking probably, yeah. So Geeta, if you want to...
Yeah, that's easier. Thank you. Thank you for the answer you gave me so far. My question is that, Simon, when you're talking about cybersecurity and these insurance things, if we have a cloud-based AI system, does it add another layer of difficulty and complexity to entire contracts and everything else, or it would be regarded the same?
I think in that regard, you are still directly liable to the user. But if, say, you're using, you know, the Amazon cloud, then, you know, you then have knock-on, Amazon are in turn liable to you for the security that they put in place. So what you would do then is you'd say in your contractual terms, you know, your data is stored in the cloud with whoever. This is subject to the terms of their privacy policy, which can be found here. So where you've got the challenge is more, you know, where in various countries, in some different countries, particularly say in a medical context, different rules apply regarding the cloud. So in some countries, I think that France and Russia certainly used to be two of them. You can't store medical data in the cloud unless it is in the cloud, but in a server located in that country. So the cloud has to be a cloud hovering over that country, as it were. So where you know, so you've always got to look at what the you know, where as well as the increased volume and complexity of the data being processed, it's cross-border as well. You've got an added layer of complication there.
Okay, got it. Thank you. So in terms of liability, I mean, we should handle it with the cloud provider rather than the customer itself, right? So that's where we should.
Yeah, I mean, that's not going to offload your liability to the customer because you're the one that's using that cloud facility. But to the extent possible, you're going to want to, you know, limit your liability in that regard. Now, yeah, if under the Data Protection Act, you know, if there is an unauthorized breach, you still may be liable, whatever the contract says in law, you know, even if you took all the possible measures, but you may, you know, have redress against your third-party provider. And also, of course, the better the measures you have in place, you know, the less, you know, the less severe the regulatory authorities are going to be with you. It's where people haven't got any measures in place, or it's quite clear they haven't got any internal procedures. I mean, and oddly enough, the medical area can be one of these where this is the case. I mean, I've known NHS trusts and private clinics where they've been really quite careless about what they do and how they treat patient data. And some of the, you know, really heinous data breaches have been in, you know, with medical data, where there's either been just carelessness among the staff or not the right technical procedures in place, or healthcare practitioners thinking that they can do a lot more with the data than they can.
Okay, got it. I mean, I have just one more question. This is my last question, promise. When you're talking about different regulations for example, France or Russia, so does it affect the, I mean, if I collect the training data, for example, in the UK, and I use that training data like a reinforcement learning, and I want to implement it in those countries, does it apply to how you train your AI, or it just is about implementation?
It's probably about implementation, but you know, how you train your AI is going to have an effect on implementation. I would say to be safe, if at all, it's the same thing with any element of using personal data is if you can at all get away with anonymizing it to do what you want to do, then do so. You know, now obviously, when you are treating an individual, you can't do that. However, if you're using collated and aggregated data for medical research, you probably can. And equally, you know, say using a smart vehicle, if you want to, you know, monitor what that driver is doing and where they're going, and that and that might be necessary as part of their job, and for health and safety and that sort of thing, then you know, that can't be anonymized. But if you're using that data more generally to do research into transport or usage patterns, then it can be.
Thank you.
Hi, so I've got a quick question, Eric Topham here. Just on the data privacy side of things, if you're an organisation that works with as a third party with other people's data, what would you say the best way of protecting yourself is? Is it primarily through contractual agreements to ensure that all the parties understand their roles and responsibilities, or is it better to try and have a set of technological solutions to doing that? So for instance, you mentioned anonymization, but actually perhaps there are other things like using federated learning for sort of distributed learning, or there's a bunch of other privacy enhancing technology that you could just apply as standard that might minimize that risk, or is it a combination of the two?
I'd use both, I think, because one then limits the possibility of anything going wrong, and the other maximizes your protection if it does go wrong.
Okay.
And remember also, with all of these things, I spoke earlier about the role of insurance in all this. The better you are at, you know, tackling those issues on both those fronts, means you're going to be viewed as a better risk on the insurance front as well. And you're going to get wider coverage and better premiums.
Okay, cool. All right, thanks. For the previous person asking, I would recommend looking at a company called X8. They've come out of HSBC. They have a platform that helps you deal with all of the issues of data sitting in different jurisdictions and how to share it and protect it and things. EXATE. They're very good.
Yeah, I mean, it is a real challenge, you know, because I think we've seen since GDPR came in, and it's certainly the case in the UK, that the sort of data protection regulatory authorities in each country, albeit to varying degrees, are quite happy to go after people, you know, if they are in breach, and find them and make an example out of them. Everyone wondered if they'd, you know, really do it, that they are, you know, and medical data and financial data are the two where in it, you know, where there is the scope for real damage, and therefore the ones that if you do suffer a breach, you can get a very damaging fine. And, you know, as I said, we're yet to see how AI and data privacy are going to be reconciled in practical and regulatory terms.
So just on that, so would you say that the closest thing to resolving that issue would be if whatever would allow you to minimize the actual movement of data from the jurisdiction that it's meant to be in? Would that effectively be the thing that cracks it? The sort of, if you could avoid literally moving, I think that's, to me, it seems often the problem is the sharing of data in the sort of almost not physical, but, you know, actually moving it from one repository to another where someone else is going to work with it and then moving it back again. So if you could just never move it, would that
I think
help?
so. I mean, obviously that's going to be increasingly difficult, but, you know, there are contractual clauses that, you know, you'd want in your contracts with third parties to cover what they're doing with, you know, with the data when you make it available to them. And as we know also, you know, different countries have varying degrees of privacy protection. and America was found wanting from a European point of view, and it's still not clear how completely that's going to be addressed, although California has brought in stricter privacy protection, so has Canada and so forth. But I think it will be a combination of, where you are doing it, sticking to the countries that have a reasonably good safeguards in place, and also making sure that you have the contractual clauses in place. But yeah, obviously the ideal thing would be if it never went anywhere, but increasingly that's going to be difficult, because the whole point of this is that things can be done in a networked and joined up fashion very quickly in multiple locations.
Yeah, no, that's interesting. I understand what you're saying. I think that there's just one really interesting sort of technology that's starting to mature, which is federated learning and distributed learning. So the idea that you don't move the data anymore to your centralized location for model training, but you ship the jobs to be executed to even down to the edge, so that you actually minimize the movement of data. So that's something we've been looking at as part of our product development model, because we feel that that's something that could potentially open a lot of doors for us, where otherwise things would be more difficult. So I'm just curious to sort of understand what the sort of the legal view around that was.
I agree with you that that it would make the risk more manageable. Yeah. I haven't looked at that facility in detail or the contractual terms, but what you say certainly makes sense. Yeah.
Yeah. Okay. Great. Thanks. Yeah, that's all I had as questions. Thank you.
Okay. Anything else? Okay. If not, as I said, we'll send out the slides, and if anyone has any questions, then please get in touch with us and reach out to us on LinkedIn in any event if you haven't already done so, and hope to see you at future events, and maybe one day we can do this face to face. Who knows?
Thank you very much. Really interesting talk. Thank you.
Thank you.